CLS Talks.
Talk to me.
CLS Talks.
Talk to me.
CLS Talks.
Talk to me.
CLS
Talk to
Talks.
me.
Real information.
Talk to me.
Real education.
Talk to me. Talk to me. They don't talk to me. They look like they want it. They don't talk to me. They want it. They don't talk to me. They want it. They don't talk to me. They want it.
Welcome back to the CLS Talks. I'm Lionel Coveney and he's Des Carty. Des, how's it going?
Great, Lionel, yourself?
Fabulous. I'll be even more fabulous now when we figure out what happened to Tom, because we've been in court, we've heard what happened, and it's Judgment Day.
Well, it's a bit of a, what do they call it? A bit of a, what's that term when it's all like very quiet and...
The calm before the storm, maybe?
No, it's not even that. It's the reverse. It's the storm before the calm.
Oh, the eye of the storm. Are we in the eye of the storm, no?
No, I think we've actually gone past
We've
the
gone
eye of the
past
storm.
it.
Yeah, it's gone through it.
We're in a maelstrom of activity then.
Yeah, it's really when Tom went in on the 4th of June, according to the book here, as they call it, Judgment Day, Tom arrived in the court and took a seat, and he had his people there with him, taking all the notes and all the rest of it. And they were lined up again to cross-examine Garda Mahoney, and they were prepared to bring in his colleagues in to cross-examine them and all the rest of it. And to cut a long story short...
Mr. Murphy, if you can keep quiet for a moment, I may be able to say something to help you.
By all means, go for it, Your Honour.
I'm dismissing this case and all charges. And the next time a guard asks to see your insurance, you might show it.
So that was 8 charges in one foul swoop.
Gone.
He
didn't even have to request that they be struck out or dismissed.
No, he was actually in the middle of moving the court to have it dismissed and struck out, or whatever. It's gone now. Now, in retrospect, and this is what we're here for today, I suppose, is to do a sort of post-case analysis of what happened. There isn't an awful lot to say, but I think you can throw in a few bits and pieces, and I'll throw in a few bits and pieces. It's always worth, again, if I can suggest this again to the listener, is to get a hold of a copy of the book and obviously go back over the sessions we've done on the Gary Doyle order and analyse them for yourself. And our analysis wasn't thorough, if you like. We didn't get into massive detail. We did cover the broad aspects of the case and very pertinent aspects of the case. But I think the readers and listeners should go back through the book, sit down with the talks while the talks are on, look at the different pages and critically analyse then the material that's contained within the book, because you can't get much more serious than a case like this in relation to traffic offences or alleged traffic offences. There's 8 charges involved in this, and most of the charges that were being proffered by the Garda, so everybody out there at one time or another will have been charged with something like this or exactly similar to this, but 8 charges are a massive amount of charges to have dismissed in one fell swoop.
Yeah.
So again, in terms of post-case analysis, I'd go back to the very beginning of this, and something that we'd reiterate is that at the outset of any case, and most cases that the state take through the Gardaí or through the councils or through any state bodies, they are defined or codified as being criminal.
Yeah, which is very, very important to note.
Yeah, so at the outset of any case, and similarly with the outset of this case, at the if you like, the post beginning of it, when Tom was in court and he wanted to say something, this is when he was removed from the prison in Dublin, Cloverhill, and brought back to Portlaoise courthouse. He did have the frame of mind or the state of mind to be able to say to the court, I'm seeking a Gary Doyle order, which is the starting block of your case in terms of the court proceedings. Again, the Gary Doyle order is based upon the DPP guidelines for prosecutors 2010, sections 8 and 9. Now you could also read all the other sections, but 8 and 9 are the most pertinent ones. Now Tom had obviously researched this material in the past through using the CLS and the Common Law Society information, and had this somewhere in his brain.
Yeah.
But most people will be in a frame or a position whereby they're more prepared even than Tom. Now the challenge always comes, and similarly with this, the judge, in retrospect, if you look back through the material and the book, the judge basically kind of denied at the outset that he was seeking a Gary Doyle order. The judge had to look back through her notes. But Tom had an accurate record of what went on and what transpired in the courthouse because he had two people there with him taking down the information critically. And he knew that he had everything word for word what was said in the court by the judge, by the Gardaí and all the rest of it. So that's where it's, as a post-case analysis, I think that's one of the key features or key start blocks for everybody, is to understand that in every case that's codified as being criminal, you have the right to have all the evidence put before you or brought to your, so you can have a look at it critically and then obviously carry out a cross-examination. And further to that, and you must remember this is covered in the DPP guidelines as well, is that disclosure is ongoing. So when you're given disclosure of documents, if you can read them critically, you can adduce there is more information, more evidence that would support those documents, and you can seek that evidence. Disclosure is not at an end once they give you the information. It only begins then.
And that is very interesting, because there is a tendency amongst us all, I think, I certainly would have been guilty of it a lot in the past, to assume that whenever we receive a letter or we're told something by a perceived authority, well then, that's it. So for example, terms and conditions apply with some contract that you sign. That's really an opening gambit, as opposed to their terms and conditions and there's nothing you can do about it. You don't have to like and lump it. So that's the same then. I mean, you can extrapolate what you want from what they have sent you and then come back to them on it and keep bouncing that ball over and back at that stage. Yeah,
it's ongoing, as you say. And that, again, I can't reiterate this well enough or often enough. The DPP guidelines gives you what the other side can do.
Yeah.
It's like, the analogy we gave before about playing poker, you can see their hand.
Yeah.
And then you can deduce what else is in the deck. So if they go and change 3 cards or 2 cards or 1 card, you actually know what that card is going to be.
Yeah.
And what other cards they can rely upon. You're allowed to see those other cards as well. So therefore, when you're putting together a cross-examination, now, on the face of it, if you read, if the listeners read through the book, they'll come to a set of questions that was asked of the Garda in question, and possibly future questions that could have been asked. The questions for the future that could have been asked were never asked. But again, looking at the post-case analysis and reading back the way the judge deposed herself or handled herself, the judge knew that this case was not just going to go away just like that. Basically, they were going to, Tom and his colleagues and his friends were going to basically really, really, really critically cross-examine the guard, and they had done a fairly good job up to that point in the first hearing or cross-examination. So they were ready to tear strips off the Garda and his other colleagues as well. They were intending on bringing his other colleagues into the stand and basically showing them up for the ignorance of the law that they had.
You see, I think that's one of the most interesting things about the case, the fact that it was withdrawn based on what had happened before, rather than any kind of dismissal being sought at that stage. It didn't even get to that.
Yeah.
I think that tells us all we need to know about where the judge knew the state's case was and what potentially could happen. Quite obviously, she was taking Tom extremely seriously at this point and realised, okay, well, we're opening a Pandora's box potentially here that we do not, as the state, want to open, because Tom, as you said, is not going away.
Well, the other thing that, in retrospect, again, looking at the post-case analysis, Tom did not get an opportunity to cross-examine the guard in relation to the guard's statement.
So was the judge protecting the guard there, do you think?
It seems, if you look at it again critically as a post-case analysis, you would take that position, I think, that the judge was protecting the Gardaí from being further cross-examined and showing up the Gardaí's ignorance of the law. Plus the fact that the judge would have been wholly aware that if the cross-examination was to continue, eventually they would have to get on to the statement of the guard and his colleague. And as was pointed out in the book, there was a direct contradiction between what the guard had said in his statement and what his colleague had said. And they hadn't even touched on that lie that was told.
Yeah.
The guard in question, Garda Mahoney, basically stated that the man, Tom, did not stop the car. the car was not stopped. But in direct contradiction of that, his colleague that was beside him on the day stated categorically that the car did stop. So that was an out and out blatant lie, which Tom had not even touched upon at this stage. And if they had gotten to that point, then there would have been further questions in relation to either the lack of knowledge of the guard in terms of law, or his proclivity to lie and then to compound the lies. Because what's he going to say? His only argument is going to be, and it has to be, according to his statement, that the car didn't stop. But then, on further cross-examination of his colleague, he'd have to say that the car did stop. So which of them is the liar?
And then you're examining the motive for the potential lie, and it becomes obvious that Garrett Mahoney is the one who's lying when you actually examine the motive, because that supports the case that they're bringing.
Correct. Now, there's other issues that, on a broader basis, the Garda Síochána, through the DPP, did not want to get into. And we touched on this before, but again, it's worth another analysis in terms of what we're talking about here today, is how can the guards stop you on the road when, they have no alleged crime? There is no alleged crime. And the only time a guard can demand a name, address, date of birth, blah, 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 and all the rest of it is when they're alleging that you've done something, and they have to tell you they suspect you of doing something criminal. Now, how is having a guard stop in the middle of the road, how can they then go to people and say, well, I want to see this and I want to see that and I want to see the other? Well, what crime have people committed? Isn't that tantamount to living in perhaps Nazi Germany, whereby you can be stopped and people can see and demand that you have ID and you carry ID with you?
Yeah.
That is tantamount to fascism, or whatever you want to call it, delineated as. How can that happen in a so-called republic?
Because it is in complete contradiction of the law.
And freedom.
Yeah.
The ability to travel freely and go about your private affairs in a free manner, which is what Tom was doing. He hadn't criminally hurt anybody or damaged anybody or stolen anything. And why was there a Garda stop on the day? Because there was no events in that area. And the only lawful reason a guard can direct traffic is when there's either an emergency or there's a large event occurring. But they can only slow down, stop, direct traffic on that basis alone.
So in other words, they can't tell you where to go when you're carrying out your private business and not committing any criminal activity.
Correct, absolutely correct. And again, that wasn't something that Tom had managed yet to get to. He hadn't actually managed to get into the detail and the nuances of all the other charges that they were putting forward against him. He'd only gone really into one specific charge, which was an absolute nonsense in terms of having to produce a licence. And it's the detail of that is in the book. And the rest of the charges that were, as they called, trumped up.
Yeah.
They just had no basis in law. There was no reason for them. The guard at the first instance should have approached Tom and said, right, I suspect you of having committed such and such a thing, blah, 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 and then moved on from that. But there should have been at least a reasonable suspicion, and there's another term for that they use, but we call it a reasonable suspicion. But there was no reasonable suspicion because the guard could not reiterate it. The guard did not say to Tom, I suspect you of having knocked somebody down or stolen something or blah, blah, blah. There was actually no allegation of a crime being committed, which is the beginning of things.
It is the case, isn't it, that all road traffic offences, if you want to call them that, are criminal. So, for example, with something like, say, for example, your tail light is out and a guard stops you for that, or your brake light, or whatever it might be, is that, from the Gardaí's point of view, if they follow procedure and protocol, which they generally don't, but if they did, is that potentially a criminal offence that the individual has committed, and is it grounds to then request the name, etc.?
Well, again, that's a question I would have to say to you, and I don't normally say this to people. I don't know.
Yeah.
I mean, if it's a crime to not have, or to have a light that's out or broken, what law is there stating that it's a crime to have a tail light broken or a light not working? I want to know the law. So I'm not going to say yes or no to your question. I'm going to say, well, show me the law that states it's a crime to have such a thing.
And another question I would potentially put then to myself when critically analysing it would be, where's the victim?
Yeah, exactly.
So, I mean, without a victim, where's the crime? You can't be convicted of a pre-crime.
Well, maybe you can.
Well, maybe you
can. A lot
of
people have.
Yeah, that's the thing. But, I mean, no. Who is to say that definitely 100% somebody would be harmed by you not having a taillight?
Well, you see, that's, as you suggest, a pre-crime, potential pre-crime, but that's no different to a thought crime, is it?
Well, it is no different. And read George Orwell, go read George Orwell's 1984. And it's not that much of a stretch to suggest that the world we're living in now is along those lines. I mean, war is peace. Obama, the peacemaker, the Nobel Peace Prize winner, many countries is it he bombed 8 in his 8 years. So I mean, everybody's up in arms now about Trump. What is he going to bomb 9? And that's people's fears.
Has he bombed any country so far?
Nobody so far, anyway.
No, I wouldn't side with any politician.
Nor would I.
But if people critically, as we suggest, analyse, well, this is Obama's record, this is Trump's record, and put them side by side and say, well, actually, on the whole, on the broader basis, which is the worst?
Yeah.
I don't know, to be honest with you, but let people analyse it critically. I mean, I have never expressed an opinion or view about Trump or Clinton or Obama. I just think all politics is corrupt. I mean, I
totally agree. Yeah.
I don't see them any different to each other. And just, if you like, as an outsider viewing what went on, money talks, doesn't it?
Absolutely.
If you've got the money to spin whatever media or promotion or advertisement that you want, you can spin yourself into being a saviour.
Yeah.
And that's it. Money talks,
And one of the really interesting things that I've noticed in a geopolitical sense is there seems to be a changing of the guard globally within politics. So you look at Brexit and Theresa May coming in, and you had the hysterical reaction from the so-called establishment and the establishment voters.
Yep.
So your regular voters who were up in arms about the fact that the vote went the unexpected way and against them. So essentially what you've had in Britain since the Brexit vote was those who espouse democracy seeking for democracy to be abolished in this case and to go against the democratic vote, okay? And you're getting the same thing now in the US with Trump. The establishment candidate, Clinton, is defeated, much to the chagrin of your establishment voters and your white middle class or whatever it is. And now all of a sudden they're calling for something to be done to get rid of democracy so that democracy can prevail.
Yeah.
I mean, if I was the puppeteer and I was dictating what's going on geopolitically, it's absolute genius. It appears to me that everything is actually fitting into place.
It's a perfect world.
It is. It's the Hegelian dialectic problem reaction solution.
Yeah.
Let's create the problem so that people will react in the way we want them to react. Then we'll offer them the solution and we'll get exactly what we wanted in the first place, which we would never have got by force. Let the people call for their own fucking execution. Excuse my French.
Excuse the language, yeah. Well, just the analogy you just given there in terms of the Hegelian dialectic, if that's the right term. Never get me tongue around that thing. But Tom has kept track of some of the members of An Garda Síochána in relation to, I think it was Portlaoise.
Yeah.
And he has since established, quite recently through monitoring certain cases, that the guard in question, Garda Mahoney, much like, and I think we've talked about this in the past, much like in the way that errant priests have been treated in the past, whereby they'd either move them to a different parish, they'd retire them, or they'd promote them. And it's usually one of the three. It's either retirement, promotion, or moving on. He has noticed recently, in tracking Garda Mahoney's affairs, that Garda Mahoney has been promoted and moved on. Garda Mahoney is now, apparently, now this is the information that Tom has given us, is now a sergeant and is not working in Portlaoise but is working in Tullamore.
Okay.
So you can see the corollary of what has been done in the past, in the recent past as well, not just in the historical past, but in the very recent past in relation to, as we call them, errant priests or paedophile priests or criminal priests, or whatever you want. The same, if you like, process seems to be entrenched in the Garda Síochána and probably similar to all other state bodies as well, whereby if there's a problem with individuals within the force or the authority or within the state, they either retire them out in the same way they've done with some judges that have acted criminally, or they promote them out of harm's way, or they move them on into a different area.
Yeah.
And that has happened. That's what they do.
So they just airbrush the problem.
Yeah, they don't actually bring charges against them for the criminal activities, behaviours, intentions, so on and so forth. They just move them on, promote them, or retire them.
And what then do you think, with regard to the case, the potential ramifications in a real sense? I mean, we know that Gardamani potentially perjured himself and that there are...
No potential about it, he did. Yeah.
So let's say that was proven through cross-examination and all this is out in the open on public record. We also know that nobody's ever been successfully prosecuted for perjury. So what in a real sense would be the ramifications? So what was the judge protecting the Gardaí from? Is it potential negative publicity, or what would it be?
Well, again, we cannot say for certain. All we can do is look at it from a critical view and say, well, our perspective would be this. The judge just wasn't protecting the guard on the face of it, which is what it looked like. The judge was also protecting her position as well, because don't forget, the judge also facilitated in the early days the unlawful imprisonment and removing of liberty for this man.
Yeah.
So it wasn't in the judge's interest to first of all continue with the case. The judge herself wanted the case gotten rid of because there was other issues in detail that were contained in the book in terms of sharing information illegally, which the judge facilitated behind the man's back, because she also gave an order for the man to have legal aid. She gave an order, she wrote an order, which the man, Tom, was not actually aware of until retrospectively he wrote to the solicitor involved that wanted to give him the legal aid. And she disclosed the fact that the judge gave her an order behind closed doors.
Which is pretty incredible when you think about it.
Yeah. So the judge wasn't just covering up for the guards, she was covering up for the solicitors, the legal system itself. So the system closes in to protect itself.
It brings us back to another case we discussed in the past on this show with Judge John O'Neill and the case there, whereby on the surface it appeared to the public that the case was lost by our man in question, but the order wasn't perfected. And because the man had made it quite clear he was willing to go down the route of judicially reviewing, then the judge just... that was his way of airbrushing that or sticking the plaster over it or whatever, and it went away from his point of view. He protected himself.
And Judge John O'Neill is still there.
He is still there.
He's in that position. And like we know of others that are in front of Judge John O'Neill and have had very similar issues. And just for the future, we think that judges are in for a bit of a shock in the near future, we'll call it, or near to medium future, because more and more people are waking up to this issue of the judicial review procedure. Now, it's not to say that it might be successful, but certainly it'll waken a few judges up, or it might get rid of a few judges as well, because they're all, as far as we can ascertain, politically appointed judges anyway. Some party allows them to go in there and sit. So what you've got in this country is there's deep corruption. It's deep ingrained corruption. It is the old boys network, if you want to call it that. And it's so deep, and it's only when you're involved in cases that you see how ingrained this is in the nature of these characters that run the legal system and the courts and the judiciary. It's really, really corrupt. I haven't experienced, if you like, the legal system in other countries, and I can't imagine it's any different. But to be involved indirectly in what we do, and you've seen yourself through classes and all the rest of it, it's shockingly, and initially it's very disturbing to look at it, but it's very shocking.
It is, and I can understand the cognitive dissonance that a lot of people experience when they come across this information first. It couldn't be true. It's so paradigm shattering once you accept the information. Like it really does change your entire view of the system that we are born into and in most cases embrace.
We've had different people that we talk to and work with and all the rest of it. They go and they have no issue going and speaking to solicitors and barristers, and they come back to us with information. And over the past 12 months specifically, we've had barristers, senior barristers and solicitors and so on and so forth, say to the people that we're talking to and dealing and talking with and working with, say to them directly, you can't do this and you can't do that. You can't actually review that judgment. You can't appeal that. You can't bring a judicial review. Can't. It's all can't, right? But of course, if you give me 20 grand, we can see what we can do.
Yeah, of course, yeah.
So our answer to that is, well, why don't we just do it, and then you can go back and tell the barrister or solicitor you've done it.
Yeah.
Forget about your can't.
Exactly. Get a new extension on the house there.
But you see, they're trying to they're feeding back. The barristers and solicitors are protecting the system by telling people, oh, you can't do that. Or, on the other hand, it'll cost you an arm and a leg if you want to do it. So which is it? You either can do it or you can't do it. But it's only when people go back and they have done it, they realise, actually, these guys it's tantamount to lying.
Yeah.
It is a lie. It's a lie. But they do that to put people off, knowing that you can do these things yourself.
Yeah.
And thus...
Well, I mean, their house of cards comes crumbling down if everybody realises that you don't need them.
Correct, absolutely. And that is again, they're protecting themselves, they're protecting the system. The whole system closes in to protect itself, and they are part of that system. You know, I'm not saying that, you know, I don't want people to take me up and say, well, all barristers, solicitors are bad people. There is good people and there's other types of people. I think primarily people are generally good, but when it comes down to protecting their position, then that's when they can become, this is where the cognitive dissonance kicks in.
Yeah.
And they allow the system to dictate to them that they should be protecting the system because that's how they're going to make a living. That's the unfortunate thing about it.
And good people do bad things, and if they perceive that it's in the interests of them personally and their family to do bad things, be it through the paycheck or something else entirely, well, a lot of people will do it.
We don't understand, and I mean, again, this information in relation to Garda Mahoney, and I'm bringing it back again to this promotion, obviously he got at some stage. We can't understand how that was possible for him to get a promotion and then for him to be moved out of the position. How can whomever was promoting him, knowing what they knew about him, knowing his record, knowing his history, knowing the fact that he took 8 charges against one man, he unlawfully arrested him, imprisoned him, so on and so forth, how can it be justified that this man gets an increase possibly in salary, a promotion, and then gets moved into probably a better position, a better location? Maybe, I don't know, I'm not sure if Tullamore is any better than Portlaoise, but you know, how can that be justified? It can't.
It can't in a moral sense anyway, in terms of...
But it can't either in a technical, legal process sense either, because would you promote somebody who was prone to criminal activity?
Not personally, certainly not, no.
Well, there has to be reasons why you would then,
Yeah.
on the opposite side of that, because I personally wouldn't, and you personally wouldn't. We would probably want to have nothing to do with them, if anything. So how can you justify then promoting somebody that you know has a track record and a history, and a proven history of criminality, which is what this was. This book is about criminality.
Yeah.
So how can you promote somebody like that? How can you make their life more comfortable? Well, that's the system closing in and protecting its own. It's like, again, I mean, I don't like making the analogy because I hate using the analogy, but it's the same as the paedophile priests.
Yeah.
They were moved on. They were promoted. They were taken out of the air, or they retired, because you can't get at them if they're retired. And similarly with judges, some judges in this country have been retired because, and similarly with the Garda Commissioner, he was retired out of it, wasn't he?
Well, yeah.
So he can't be touched.
Yeah.
Was it Martin Callanan, is it?
Martin Callanan, yeah.
So you can see the pattern. You start getting at these characters and they'll get moved on, moved out, retired, blah blah blah, and then it's not that they're untouchable, but you get the sense that they are untouchable.
Yeah.
You know, so it's a hard battle to beat, or sorry, not beat, but to win your case first of all, and then to actually get reparations for the damages that were done to you, because these people disappear.
And that's quite often overlooked as well, because so many of us were so delighted to have the stress removed if we win a case, or a case is dismissed, or whatever it might be. And people quite often forget, again, myself included in the past, that it doesn't have to end there. I mean, you can further protect yourself, not just in a financial sense and get money from them or whatever, but you can further protect yourself in terms of laying down the track record, right? Here's me, and here's what happens if you attempt to do wrong to me. Yeah. Because here's what I've done in the past to A, B, C or D, through following up on the case and then deciding what course of action to take. But I mean, you can then go on the attack if you're so inclined, using the same knowledge.
Yeah. Well, again, okay, without diverting too far away from the book itself, I'll bring it back to people notice the content of the book and the dynamics that happened in the court. The court made sure that there was very few of members of the public. There was no press in there as well. So this was never going to get out into the public media and get onto the 10 o'clock news or whatever it might be, as a man actually... Now, it's unheard of where a man would walk into a court and beat 8 charges and then it not be publicised in a paper.
Yeah.
Isn't it?
Well, you would imagine it would be.
You know, they publicise everything else. If a man gets put down for or has no tax, or the car is taken off him, or whatever, all the minor stuff.
Yeah, or doesn't know the difference between garlic and apples, for
Correct.
example.
There you
Yeah.
go. That's all publicised and highlighted, but that's a win for the court, you see, and the judicial system.
Yeah.
But when it's the flip of the coin is, well, the man has actually beaten 8 charges, you know, and, you know, rightly so. You know, we're not saying he's just gotten off on this. He should never have been in the court to start with. But that's not publicised.
No, the only time a lay litigant ever gets any publicity is when it's somebody goes in, I mean, we'll use the broad term here, a free man, for example, and we've discussed that extensively if people want to know exactly what I mean when I say that. But if a free man goes into the court, messes up and loses,
Oh, yeah.
and that's when you'll hear about lay litigants, and everybody gets tarred then with that brush.
Yeah.
And there is, as you say, no mention of anybody who actually critically analyses and learns the law to protect themselves and successfully does so. Never anything, ever.
Now, again, just like I don't think we can say, we could say an awful lot more in terms of post analysis of the case and all the rest of it. But again, I'd be saying to the listeners, and perhaps you'd agree with this or not, to get to a point where you're able to walk into a court and be comfortable and confident. I don't think anybody's ever comfortable and confident, but to get to a point where you can actually get this stuff out, speak directly to a judge, perhaps as an equal, or perhaps the way it should be that they're the servant, you're not. That's ideally the way it should be, and the judge should be doing what you say to them. But to get to a point where Tom was able to walk into the court and relatively confidently ask the questions and cross-examine the guard, that took an awful lot of work.
I'd imagine so, yeah.
And you know yourself, and I know myself, the work that's involved in critically reading material, then writing material, then analysing it to make sure it's tight, and then making sure that everything you've asked then is relevant, pertinent, can't be challenged, blah, blah, blah. The work involved, like you're talking about hundreds of hours of work. So for us to say to people, right, just go in there and ask for a Gary Doyle order, I understand the difficulty in getting your head around being able to even talk to a judge in that context and say to a judge, no, I insist, I want full disclosure on this, and the burden of proof is on the accuser, it's not on me, as you well know, because the judges do stand there and say, well, what do you know about it?
Yeah.
Do you know? I'm not sure what a Gary Doyle. If the judges have been saying that,
and they frequently do.
Yeah. So, like, not to put too fine a point on it, I think if you're going to go in, and I've had this discussion with other people before, if you're not prepared to put in the study and the work pre going into the court, I think sometimes you're well off to say, oh, fair enough, I'll pay the fine.
I agree.
Yeah.
Pick your battles, and if you're not going to see the battle through, well, then you're going to lose. So if you plan on losing, well, aren't you better off losing before you actually go into battle and just surrender beforehand and stay alive?
And get over it.
Yeah.
That's it. Yeah. As you say, pick your battles. Like, I mean, I don't know myself now which way I'd go. Even today, I just have to look at the situation, depending on my family situation, depending on my circumstances, and I wouldn't try to justify it either way for anybody. This is just the way I just make my decisions on the day. So I don't have any umbrage with people who have decided to pay fines or fees or charges. But there will come a point in time, if you're listening critically to what we're saying, that you'll have to say, well, look, I've had enough.
Yeah.
You know, we discussed this right at the very beginning of the talks. You know, enough is enough. And be ready for that. And in the meantime, as you say, pick your little battles if you want to have any battles. Now, be cognizant of this as well, be conscious of this, and know this, that we call them battles, but they're, in effect, what you're doing is creating a war.
Yeah.
And what happens in between the beginning of the war and the end of the war are battles.
Yeah, and there are many of them. A letter is a battle, for example.
So something that is perceivably minor can potentially turn into a war of attrition, and you have your battles in between. But if you start the war, you don't start the war unless you intend to win.
Well, absolutely, because you'll be made mincemeat of otherwise.
And the only time this is finished is when you have won, not when they have won.
Yeah.
That's the only time it's finished, because, as we suggested before, you can do review of judgments, you can do appeals, you can do judicial reviews, you can do all sorts of things. And every time you walk out of that court and you have not been prosecuted, it's a win.
Yeah.
It's a winning battle. You've won that little battle for that day.
The war essentially continues until you concede.
Either you concede or they concede.
Or they concede, yeah.
Yeah. But you do not, we can't make too fine a point of this, you don't start a war unless you're prepared to go all the way and unless at the beginning you've decided you're going to win the war. You don't start a war unless that criteria is laid down in place, and it's a psychological criteria. You have to decide in your head, I'm starting this, or I'm engaging in this rather than starting, because generally you do not start the wars.
Yeah.
You're engaging in it, and I'm not finished until I win.
Yeah. And it's so important. It's just so important. And it can be quite a jump for a lot of people because you have your daily considerations. And as you say, it's time consuming, hundreds of hours. Who knows what's going to happen? What will the neighbours think? What will the friends and family think? You've all of that.
Well,
to
the neighbours
consider.
are very important.
Very, very important. And make sure that if they get a new cobblestone driveway, you do the same too.
Every time.
Every single time.
Now, is there anything else we need to throw at this?
I think that ties it up. I've one question, and I think it is one that potentially we will be asked. Did Tom get the car back?
No, he didn't. No. But he's still pursuing that avenue at the moment.
Okay.
Again, it
wasn't his car even.
No, it wasn't his car, and he has made reparations to the friend of his that he borrowed it from, so he has to get reparations himself. Now, he hasn't desisted from that, and he still is engaged with getting through that process. That's why he was able to tell us of late that where Garda Mahoney was and what he was doing. But again, he has to confirm a few bits and pieces, and then he'll hit them again with something else.
Yeah.
But he hasn't given up, and he has said to me that he has not, since that event, since the winning of his case per se, he's never been harassed by the guards in any context.
Yeah, well, that's interesting in itself.
So he has gone through checkpoints and they've just waved him on.
Wow.
Now, not to say that will continue or whatever, but certainly in the locale that he drives around, or travels around, I should say, the guards just leave him alone. So
the moral of the story is never borrow a Ferrari.
That's it. You attract attention.
That's it. So hopefully people have found it informative. It's taken quite a number of episodes to get to where we did, but for me, the thing that I've extrapolated most from the discussion and from the book is talking about the war analogy again. Don't go to war without the weapons.
Yeah, absolutely.
And the weapons are there. They're there to be freely used, so use them. Would you go into war or into battle without your weapons? Of course you wouldn't, so don't do it in a legal sense either. And the Gary Doyle order is a huge weapon. It's a cannon, you know.
Well, we did discuss this before, and perhaps in the new year we'll work on doing something like this, perhaps analysing the art of war.
Absolutely, I think that'd be a great one. And some people in feedback had said they would like to hear that.
Yeah.
So
we'll have to reread the flipping thing again.
Exactly, again and again and again.
Well, just there's one thing I want to end on from our end, if you like, is that the next session we're doing is going to be the Christmas special. And we'd like everybody obviously to tune in, and we'll try and do it as live as possible. Yeah. And the one thing I'll say it now so that people have a bit of time to look at this, is that we're going to afford a prize, we'll call it, for lack of a better word, of a set of books, a set of the CLS talks, and some other bits and pieces. We'll put together a package, a little bit of a hamper for Christmas. And I'll leave it to you, Lionel, to see if there's a question you'd like to ask the listeners. We'll try and get something today out to them. And what we'll do is we'll put all the names into a hat, and we'll do the draw on the Christmas special.
Sounds
talk.
good.
Yeah.
So the question then.
The question. Think of a question now. This is it. Something related directly to the book, so they have to actually do a bit of research, perhaps.
Okay, give me a second on this.
No. I'm putting you on the spot now. You have to tell me what the question is. I don't have any question in mind. We'll flick through and see if there's something. All right, what about this?
Can I seek an adjournment?
Yeah, you can seek an adjournment. How about this then? Now, we want a brief answer on this. In terms of, we want to know where you would find a reference to what we've called the Gary Doyle order. A very relevant question. So we want you to give us the act or legislation under which a Gary Doyle order can be instituted. And we've mentioned this several times. Now, listen, guys, it's all over the book. So we want you to tell us the year in terms of the act under the DPP guidelines. The year. All we want is the year. So you tell us the year under which the DPP guidelines refer to the Gary Doyle order. So that's not a difficult question.
No, that's a good one. And the email address, of course, is
info@thecommonlawsociety.com.
We look forward to the entries.
Okay, thanks very much, folks.
It's been a pleasure. We'll see you at the Christmas special, Des.
Look.
CLS Talks.